Hi, everybody. Welcome to the February edition of the Third Fridays podcast. We're live from the Kill Room. Although there are some books in the background, I guess that makes it less dextery and more cozy. If you're watching this on video, I have two guests today. It's a first, and it makes it all the more important to me because our esteemed leader, Greg Lois, is manning the controls and is not a guest. He has not passed muster to make it on. But there will be some day. I promise one day we will get him on. Sadly enough, actually, for all the people who contact me about the podcast, they never ask to see the video version. So maybe it's just I have a face for radio. But maybe that's what I'm bringing Amy and Jeremy on the show. Welcome, guys.
Hello, listeners out there. I'm so stoked to be here today.
Okay, we don't usually use stoked in the podcast, but there's a first for everything. Amy, what do you do here at Lois?
I am so honored to say that I am your paralegal. Mainly, I'm also Jeremy's paralegal.
Mainly Jeremy's paralegal. Okay.
And if you watch the after show, I will tell you who I like better of the two.
The after show. Am I going to be part of that? Is that just some kind of off
No, that's
take?
something that Greg does after you leave.
Okay. That's weird and creepy, but okay. So, as everybody has been listening to what we're doing with the podcast now, we're doing them in conjunction with the New York webinar series to make it an obvious link, whereas the webinar series talks about 101 level issues for a certain topic, right? And this month's topic is appeals. So I thought it was natural to have you guys both on to talk about what kind of developments have occurred in our world and what, the three of us have spearheaded to make sure that we're representing our clients with best efforts. So kind of all started, I guess maybe a year ago when we went to the spring meeting of the Self-Insured Association, and there were rumors about board panel decisions coming down without any kind of ruling on the merits, right? Jeremy, does that ring a bell?
Sounds about right.
Right? So what did those decisions essentially say, like that were starting to come down from the board? What were they doing?
The board has a rule 300.13 that discusses how to fill out forms such as an RB89, RB89.1, and RB89.2 properly. It explains that the application has to be filled out completely and fully, and you have to give certain types of answers within each one of the questions, meaning that you have to disclose what documents you're using, what the issue of the appeal is, and what exception was noted at the hearing.
Right. So, which is all not wrong. It's not anything different that had been happening before, right? I mean, we've been filing RB89s for years, so have other firms on both sides, and both sides have been doing it the same way all this time. And at some point, the board decided to say that it wasn't good enough. Would that be fair to say?
Sounds about right.
Okay. So I imagine this is like, you're in a relationship with someone, right? And you've been taking the trash out as part of your delegation of duties every week or every 2 days or however the system is, right?
Yes.
And then your partner comes to you and says, well, you're not doing it at 6:31 p.m. on Tuesdays and 4:18 a.m. on Fridays because I wanted you to do it 5 minutes before it was picked up, right?
Right.
But it didn't reverse any of the times that you dutifully took out the trash for really how long you've been together.
Right.
Right?
Yes.
That is unfair.
Yes.
And one might say it's arbitrary and capricious.
I think my paralegal has done some homework.
Yes.
Yes. So, okay. We've been getting these decisions. Claimant side has been getting these decisions. What has been our action plan, Jeremy, to combat this?
We've found numerous clients that have been willing to go along with appealing these findings, as we feel they're just randomly enforced at a certain point. In doing research, we found that April 11th, for some reason, was a date they picked where they started to enforce this at some point.
Yeah,
more completely.
I kind of want to know, like, what happened during, like, the meeting on April 10th.
Right.
Yeah. Like, it's like they're preparing to change the world here and not even tell anybody. And what really brought about this change, right? And you could say anything, really. I mean, ultimately, I'm sure the board panel has been flooded with appeals from both sides, right? I've always thought to prevent appeals from either side is to have judges make the correct decisions, right? That's first and foremost. But sometimes even a correct decision by a law judge will be appealed by the other side, and that goes both ways. So even that solution on my end doesn't actually fix the problem entirely. But we have a different problem here now. So like you said, clients have authorized us to be more aggressive by going to the full board and the third department.
Yes.
Right? Okay. In response to the first onslaught of appeals from both sides, what has been the board's response?
Well, first of all, Thanksgiving weekend, actually the Friday of Thanksgiving weekend, which is the one day everybody has off, the board decided to randomly issue a bulletin in which they provide guidance on how to properly fill out the RB89 and RB89.2 and 3 forms properly.
That's an interesting point that you bring up, because the new 2018 SLU guidelines was also released on the same weekend, the year before. And it was like, okay, who's as crazy as I am that's going to read this during their tryptophan-induced coma? Not many people, but it's a good point, right? Just flooding the market at a time when no one's really paying attention yet. That certainly was a big deal when it came out. So can you go into a little bit what this little memo or bulletin talked about?
It pretty much
gave examples,
provide guidance as to what was sufficient under the 300.13, what would be rejected immediately. So, for instance, if you were appealing ANCR, it actually made it simpler on that end. You would just put ANCR, but it also changed some things, like where you disclose you now have to list every hearing where a issue was potentially addressed, even tangentially.
Right.
You need to make sure you refer to every document in there or risk getting rejected. And further, you need to note exactly what your exception was and what hearing it was made at.
Right. So if we go back to taking out the trash, right, because you used that example before, it would be as if I was, or we, the collective we, were being punished for not taking the trash out at the time specified by our partner. Mm-hmm. And then 6 months later, after they told us that we were taking it out wrong, they were then saying, this is how you should take it out, right?
Right.
Yes.
So if I think about just normal common sense, right, that's backwards, right?
Of course.
Tell someone, if you want to go to the length of telling someone how to do it, you do it before you take the remedial action, right?
Of course.
And we like to think of administrative law as more, I don't want to say informal, but more directed towards finding the right endpoint, right? Without going through procedural red tape, right? That's really something that happens in civil court a lot, right? Make sure you do something with this sheet of paper and file it with the clerk at this location, right? Like, administrative law doesn't usually have those kinds of requirements. So I always looked at this little bulletin as kind of like a oopsies. Like if we were going to start doing this, should we have provided this kind of notice to everybody beforehand? Because throwing out appeals for not putting the date of a hearing in one box, but when the date of the hearing is in a different box,
right,
it seems a little bit out there.
Right.
I think it's essentially the other part of it is that they had been allowing it for years and years, and it had been sufficient, and then one day they just decided it wasn't sufficient any longer.
Right. So, now, right, the bulletin comes out, and and Amy, how much more time are you spending looking at each box on those RB89s that you're drafting?
I am spending significantly more time. I am, if anything, just overdoing every box and just stating redundantly what the objections and exceptions were made at the hearing, even though the brief is stating the same and even though the first two boxes on the cover sheet are stating the same.
Right. It's almost it's overdoing it, right? Just for the sake of conserving resources that you would later have to spend because the continued abuse of discretion is going to come back, right? Until the third department looks at this and decides, what is the real issue here, right? So, okay, bulletin comes out. We're now tailoring our RB89 approach to something more, right? To something more intricate and making sure that those filings are not going to get bounced back, right?
Right.
Okay. Now, something else has also changed in the recent past with the appellate division, right? So, Jeremy, can you talk a little bit about like deadlines and maybe some changes to how and when we submit filings to perfect our third department appeals?
So the appellate division recently changed its rules. This rule change went into effect in September of 2018.
Right.
And part of just on the cover page of the new statute, they list that this will be enforced for all prior appeals as well. So anything that was pending before the court, it would also be enforced.
It's an important distinction, right? I mean, because if you're going to apply something retroactively, you'd have to give parties the opportunity to react. And I think that's where the third department has actually taken a little bit of a softer stance by saying, okay, I'm changing the timeline by 3 months, but you can still file an extension request if you think you can't meet the new timeline, right? Which seems to be a little bit more in the line of common sense. But that's really to kind of tell our audience, you have third department appeals pending. You probably have more based on these board panel decisions that are arbitrarily denying appeals. But now that you have them, it's time to file those extension requests. And, the whisper is, if you're not doing it, send it over here. We'll do it for you, right? We'll file those extension requests and get back the relief that you need before the board, right?
So the biggest change is now, instead of taking 9 months to perfect an appeal, you now only have 6 months.
Right. And with the 6-month timeline, you're filing everything with the record and the brief is filed at the same time now too, right?
So the initial part of it, the filing of the notice of appeal, the proposed records list, all remains the same. So that's within the first 45 days and then 30 days later. So within the first 75 days, everything remains exactly the same. But thereafter, things have now changed.
Right. Okay, so game planning now as a team to kind of focus our firm on putting forth the best foot forward, right? We've been talking to clerks. We've been talking to, binding and printing companies to kind of get everybody's take on it and make the best decision. What kind of things have you guys learned from talking to these types of people?
Sure. Well, I called the third department the other day. They were very helpful.
Not in preparation for this podcast at all, right?
No, actually.
Okay.
They were very helpful, and they informed us that the extension requests no longer have to be formal motions. They can just be a simple letter, and that they will be routinely granted.
Okay.
And an answer will be provided via regular mail within a week. They said that they were a little backed up recently, but that normally that's how it will be handled, with the exception of those appeals who have already passed the 6 months. If you've already passed the 6 months, it won't be granted, and you'll have to automatically file a motion to vacate a dismissal.
Okay. So here we now have administrative law and kind of appellate law juxtaposed, but really doing what the other is really intended to do, right? And administrative law, like I said, is not supposed to be filled with, red tape and procedural nonsense, right? We get to the end point in the most efficient way, right? whereas appellate practice has a lot of requirements that attorneys practicing before them have to commit to, right? Service, timelines that are way more intricate and time specific, right? The appellate division's now saying, yeah, go file an extension request. We've changed these rules.
Right.
Board panel is saying, we've changed these rules. We're just not going to tell you until after the fact, but still deny the appeals that are pending, right? So even when the first decision came out on April 11th, right, there were appeals pending and filed before that didn't get a chance to really file the administrative equivalent of an extension request, right? So it's a little bit of an odd change for both areas, and I think we have to make sure that we know what our clients' interests are at all times, and also be prepared to present opportunities and options going forward. Does that make sense?
Definitely.
Yes.
Okay, cool. So I'm glad that you're just nodding along. It's great knowing that I have carte blanche to just say whatever I want, right? Great.
As per usual.
Okay. All right. Everybody can please disregard that. But so on the subject of appeals, right? Obviously, if we're doing a podcast on appeals, felt like it would have been worth it to look at recent appellate division decisions, and I came across this case that talked about schedule loss of use. Right? Schedule loss of use has been one of our clients' biggest problems. Right? You bump into a door, hurt your shoulder, you don't lose any time from work, and because you have some subjective range of motion, you get an award at the end of the day, right? That's problematic because the system's designed to compensate for permanent injuries, right? But if you haven't lost time from work, it doesn't really make sense that you should get an award, right? It also occurs, or this situation occurs, when sometimes you have an arm injury that has a shoulder injury and an elbow injury separately, but there's only a schedule loss of use opinion for the arm, right? Oftentimes, doctors will find a percentage loss of use of the elbow and a percentage loss of use of the shoulder. So, Jeremy, what is the, what's the threat or the potential problem with finding two separate percentages? What could possibly happen?
So the usual practice is that the law judge will just add the two together.
Right.
So let's say you have a 25 and a 30, one for the elbow, one for the shoulder. That's above 50%, so that's a 55%. You have the possibility then of 15-3V, which means the claimant, in addition to the schedule, the claimant might at some point be entitled to a loss of wage earning capacity.
And that's very problematic, right? So I wanted to talk about this decision. It just came out yesterday. It's called Matter of Bell versus Glen Falls Ready Mix, and the law judge did exactly that. It was 50% of the shoulder and 30% of the elbow, right?
Wow.
For an 80% loss of use. I want you to think about losing 80% of the use of your arm. Think about how bad that would have to be. That's close to the complete loss of use of your arm. You might as well chop my arm off, right? If I can't use 80% of it, I might as well chop it off. But in comp, I guess you can get findings where really it's not really 80%, right? So the board panel rejected this finding by the judge and said, no, look at the major deficit, and then if any special considerations apply, that can be added. But it's not just an A plus B equals C.
Right.
It's really, is A greater than B? Use A, and then if there's anything else to go after it, go to C. So the claimant appeals, of course. Why not, right? Instead of 60%, I want 80%, even though, I have probably 25% loss of use of my arm. I'm just not telling anybody, right? So the third department comes back and they say that the schedule is focused on the highest valued part of the extremity. In case of a high schedule for one part of the extremity, calculate first for the major loss in part involved. If there are additional defects, for example, of the elbow, add 10% to the loss of use of the major part, and the final schedule will be that calculation, right? That actually makes more sense, And this decision, it's not groundbreaking, but I think the recency of it and the problems that scheduled loss of use is facing with the new guidelines and people who haven't lost time from work, I think it's important to really bring up and remind our clients, employers, and maybe, I guess, remind people who aren't our clients, wink, wink, right, that these are things that we can do to lower exposure, right? You lower the exposure of a 50 plus 30, it's not 80, it might be 60, right? And that becomes your worst case scenario, right? It means that your compromise scenario is lower, and it means that you have more information to go to litigation with, right? Is that fair?
Absolutely.
Definitely.
Right. And like you said, if you want to make a deal, right, you want to actually come with an informed basis, right? It's not just, oh, I have 50 and 30, that's an 80. You have a 0, so let's give you 40. Like a 40% loss of use is still almost half loss of use of your arm.
Right.
Right? So like what employer or carrier wants to submit to that compromise when the person hasn't lost time from work?
Absolutely.
Okay. So we have a recent decision, and we've talked about what we're doing appeal-wise, right? We've talked about how the board panel has decided some cases and what we're doing. And then you guys have actually talked with people from the third department, and I kind of appreciate that because now it adds us to really come full circle, right? And the full circle is, one, we're spending more time on the RB89s to make sure that this doesn't happen, right?
Yeah.
Right.
And for the cases that it's happening, right, we're digging our heels in the sand.
Absolutely.
And we're saying that it's an abuse of discretion, right?
Yes.
Right? So when these decisions come out, right, you may see these two people again, and we'll see how the court rules on it, right?
Yeah.
Yeah.
I look forward to it.
Okay. So thank you to Jeremy Janis. My name is Christian Cison, and Amy Figueroa. What do we remind everybody to do?
Defend from day one.
Oh, I've taught you well. This is so great. All right. Happy Valentine's Day, everybody.